If you are an immigrant living in the United States, a green card holder, a visa holder, an international student, a naturalized citizen, or even someone who has been filing taxes with an ITIN number for years, what I am about to share with you today could affect your financial future in ways you may never have imagined. In fact, there's a good chance that many people watching this video have already encountered the issue we are about to discuss, and simply did not realize it. Some have foreign bank accounts they opened years ago before moving to America. Some inherited savings from parents or grandparents overseas. Some regularly send money to family members in another country. Others own property abroad, maintain retirement accounts in their country of birth, or keep emergency savings in a foreign bank because that is where they lived for most of their lives. For millions of immigrants, these situations are completely normal. Yet what many people do not realize is that under U.S. law, certain foreign financial accounts and assets may trigger reporting obligations that exist regardless of whether the money was earned legally, taxed properly, or simply sitting untouched in an account for years. Now, before we go any further, I want to make something absolutely clear. This video is not intended to scare you. It is not intended to create panic or anxiety. The purpose of this video is preparation. The goal is to help you understand how the system works, why these rules exist, who may be affected, and what practical steps you can take to avoid unnecessary problems in the future. Because when it comes to immigration, taxes, financial reporting, and government compliance, one of the most expensive mistakes a person can make is assuming that something does not apply to them simply because nobody ever explained it. Every year, thousands of people discover reporting requirements they never knew existed. Some discover them during tax preparation. Others learn about them while applying for immigration benefits. Some find out when speaking with attorneys. And unfortunately, some only discover them after receiving letters, notices, or requests for additional information. The reality is that ignorance of a reporting requirement does not necessarily eliminate the obligation itself. Imagine for a moment that you arrived in the United States 15 years ago. You worked hard, followed the rules, paid your taxes, built a career, purchased a home, raised a family, and eventually obtained lawful permanent residence. During all those years, you kept a savings account in your home country. Maybe the account contained money your parents helped you save before you left. Maybe it held funds from a property sale. Maybe it was simply an emergency account you never closed. You never touched the money. You never thought about it. It sat quietly in the background while you focused on building your life in America. Then one day, while preparing documents for citizenship, an attorney asks whether you have foreign financial accounts. You answer yes. The attorney asks if you have ever filed an FBAR. Suddenly, you are confused. What is an FBAR? Why would you need to report an account that was never hidden, never used for illegal purposes, and never generated significant income? That moment of confusion happens far more often than most people realize. To understand why, we need to step back and look at how the United States approaches taxation and financial reporting. Unlike many countries that primarily tax income earned within their borders, the United States operates under a system that can require reporting of worldwide income and certain foreign financial interests for U.S. persons. This framework has existed for many years, but over the last 2 decades, technological advances, international agreements, and financial transparency initiatives have dramatically increased the amount of information available to regulatory agencies. Governments around the world now cooperate in ways that would have seemed impossible a generation ago. Financial institutions share information. International reporting systems have expanded. Cross-border financial activity is monitored more closely than ever before. As a result, individuals who maintain financial connections outside the United States must understand their obligations in order to remain compliant. One of the most commonly misunderstood requirements involves something known as FBAR reporting. FBAR stands for Foreign Bank Account Report. The name sounds technical and intimidating, but the underlying concept is relatively straightforward. Certain individuals who have financial interests in or authority over foreign financial accounts may be required to report those accounts if the combined value exceeds a specific threshold during the year. What surprises many people is that this threshold applies to the aggregate value of all qualifying foreign accounts combined. It is not necessarily based on the average balance. It is not limited to one account. A temporary increase in account balances due to a property sale, inheritance, family transfer, or business transaction may trigger reporting requirements even if the funds were only present briefly. This is one of the reasons why so many individuals accidentally overlook the requirement. They assume the rule applies only to wealthy investors with large international portfolios, when in reality it may affect ordinary families maintaining perfectly legitimate financial accounts abroad. Now let us talk about something that creates enormous confusion within immigrant communities. Many people believe that if money was earned legally and taxes were paid in the country where the money originated, then no further reporting is necessary in the United States. Unfortunately, reporting requirements and taxation are not always the same thing. A person may owe no additional tax whatsoever and still have reporting obligations. That distinction is critically important. Reporting requirements exist independently of whether additional taxes are due. This is why so many compliance issues arise. People focus on taxes and overlook reporting. Then years later they discover that forms should have been filed even though no tax liability existed. Understanding this distinction can save tremendous stress, legal expenses, and uncertainty later on. Another term you may have heard is FATCA, which stands for the Foreign Account Tax Compliance Act. FATCA fundamentally changed the relationship between international financial institutions and U.S. reporting requirements. Under FATCA, many foreign banks and financial institutions participate in information-sharing frameworks involving U.S.-connected account holders. As a result, financial transparency has increased significantly over time. What this means in practical terms is that maintaining accurate records and complying with reporting requirements has become more important than ever before. The days when people assumed foreign accounts existed completely outside the view of regulators are largely over. The modern financial system is interconnected in ways that continue to evolve every year. For immigrants, these developments raise understandable questions. What if I inherited an account overseas? What if my parents added my name to a family account decades ago? What if I have signature authority over an account that technically belongs to a relative? What if I own property abroad that generates rental income? What if I have retirement savings in another country? These are all legitimate questions, and the answers often depend on specific facts and circumstances. That is why individualized legal and tax advice is so important. General information can help identify potential issues, but only qualified professionals can evaluate the details of a person's unique situation. At the same time, there is good news. Most compliance issues are preventable. Most problems can be addressed proactively. The people who experience the best outcomes are usually not those with the most money or resources. They are the people who stay informed, maintain organized records, file required forms on time, and seek professional guidance whenever uncertainty arises. Preparation remains one of the most powerful forms of protection available. Just as immigrants carefully prepare immigration applications, maintain copies of important documents, and keep records of travel history, they should also maintain organized financial records and understand their reporting responsibilities. This becomes particularly important because financial history and immigration history often intersect. Immigration applications frequently ask questions related to tax compliance, income, employment, financial support, and legal obligations. Tax returns are commonly used as supporting evidence in immigration cases. Sponsorship applications rely heavily on financial documentation. Naturalization applicants may be asked about tax filing history. Green card applicants may need to demonstrate compliance with various obligations. None of this means that every reporting issue automatically becomes an immigration problem. However, maintaining accurate records and addressing concerns proactively can make future immigration processes smoother and less stressful. Another area that deserves attention involves ITIN holders. For many years, millions of individuals have used individual taxpayer identification numbers to comply with federal tax laws. These individuals often filed taxes despite having no legal obligation to do so, because they wanted to demonstrate responsibility and establish positive records. Tax compliance has long been viewed as a constructive factor within the immigration system. Maintaining accurate tax filings, keeping copies of returns, and preserving financial records can provide valuable documentation for future immigration benefits. This is one reason why immigration attorneys frequently emphasize the importance of filing taxes accurately and consistently. As we continue through this discussion, I want you to think about your own circumstances. Do you have financial accounts outside the United States? Do you send money internationally? Have you inherited assets abroad? Do you own property in another country? Have you ever been added to a family account without thinking much about it? Have you reviewed your reporting obligations recently? If not, now may be the perfect time to begin asking questions and gathering information. Because the most dangerous compliance issue is often the one you do not know exists. The truth is that financial compliance does not have to be frightening. It does not have to be overwhelming. In many cases, the solution begins with education, organization, and awareness. The more you understand the rules, the more confidently you can navigate them, and confidence matters. Whether you are pursuing a green card, renewing a visa, applying for citizenship, sponsoring family members, or simply building a stable future in America, understanding your financial obligations helps create peace of mind. It allows you to move forward knowing that you have taken responsible steps to protect yourself and your loved ones. So in today's video, we are going to break down everything you need to know about foreign bank account reporting, FBAR requirements, FATCA rules, ITIN compliance, international money transfers, overseas assets, immigration implications, tax filing responsibilities, common mistakes immigrants make, and practical actions you can take right now. By the end of this video, you will have a much clearer understanding of how these systems work, who may be affected, and what resources are available if you discover that you need additional guidance. Because when it comes to protecting your future in the United States, information is not just helpful. Information is one of the most valuable assets you can possess.